Body of order, item number 1.
My lord.
For reasons mentioned in the orders, both the petitioners are allowed to go on bail of rupees 50,000 each with one surety of like amount subject to certain conditions.
Deeply obliged, my lord.
Please, your lordship. Lordship, prayer for listing lordship and the hearing matter, the AV lordship went on Friday lordship was listed, but leftover matter lordship and the bank employee, manager of the bank lordship, SBI. And CD is available lordship on that day was. Can we, they have
Court,
published.
Regular bill is for listing the same matter of which tomorrow look at item number 19, court number 22.
okay, before court number 22.
The court has the senior bench.
Okay, no, it will be listed, but before court number 22. Prayer is allowed. Give one mention memo.
Court number 22.
Yes.
May it be Lordship, I beg to mention one interlocutory application
Regarding,
regarding little modification of the order passed by your lordship.
some error is there,
A little, a little
modification of the condition. Yes. Third, day after tomorrow. Okay, tomorrow.
Happy lord. What's again item number 2, we file an affidavit. That may be called for. Today,
Item number
item number 2.
2. Okay,
Mother.
let the affidavit.
I beg to mention for a AB for withdrawal tomorrow.
Okay,
I have a prayer for listing of 2 matters, otherwise before the civil bench was parted before your lordships. Because the interim order was the last date these matters were listed, lordships bench did not take. Before the trial court, we are facing certain difficulty. It can be only taken up only for the purpose of interim order day after tomorrow. Because I am led by learned senior counsel Mr. Singh. Will be available.
but this bench is,
I'm aware, ma'am. Those matters are parted before your lord. Only for the purpose, because otherwise, no, we are facing a genuine problem before the trial. It is insisting on the interim order extended. So that limited purpose
okay, on third,
on Wednesday.
on Wednesday.
Deeply.
May please, your lordship, I'm praying for listing of an anticipated bail application on 3rd of September, your lord.
When have you filed?
On Saturday, your lord.
Okay,
Deeply of the lordship.
Martin, you.
Item 2.
Let the affidavit, they have filed an affidavit.
Yes.
Let it come on record.
No issues, lordship. Or an extra copy can be given to the honorable court, or our copy we can give it to
We
them.
have,
You have received the affidavit.
We have received the copy.
we have copied some.
Okay, give me a
Yes.
copy.
Okay.
You are otherwise ready.
Yes, otherwise ready.
Okay, give me a copy of the.
With me.
Their ground was, the plea of the petitioner was that you have not mentioned reasons for arresting the petitioner.
It is there.
You flag the page number. While forwarding the petitioner before the magistrate, in the forwarding report, have you mentioned
Provision. BMS is निकालो. 41 extra.
41 एक जगह 44.
you have anything to submit
Regarding the affidavit,
affidavit here?
I have no, whatever is written, we'll accept that, no issue. We will make my submissions. I'll go through the affidavit, my friends, colleagues are going through it. I'll make my submission, no issue.
Single complete this argument that I'll.
Yes.
Yes. So my first submission is that whether they still have the objection of my appearing in this case. If they have objection, then I'll address that case issue first. If they do not have objection, then I will argue on the bail.
Yes, Mr. K.
Lordship, that is a pertinent question to be decided by Lordship. I'm placing to,
You are objecting to,
yes, Lordship, because I understand to have appointed under section 165 of the Constitution. One 165. The Constitution.
yes. Yes,
The governor of each state shall appoint a person who is qualified to be appointed a judge of the High Court to be Advocate General for the state. Now, Lordship may come to Article 266.
yes,
Consolidated Fund and Public Account of India. Dear Lordship, in this of the state, yet all the tax collected by the state deposit in the consolidated fund. This is a part of the Constitution. Then Article 267 is a contingency fund. All of things importantly, Section 269 capital A. It was brought by Constitution Amendment of 101. Not. It knows the GST was promulgated for 1st of July 2017.
yes,
Now, Lordship, I want to place section 6 of the Assam GST Act. Section 6. The Lordship, not act, indirect, I could not download. The section 6 is the important. Without prejudice to the provision of this act, the officers appointed under the Central Goods and Service Tax Acts are authorized to be the proper official for the purpose of this act, subject to such condition as the government shall, on recommendation of the council by notification specified. But if here mentioned is about the council, all the state finance ministers are the member of the councils. They decide how to tax to be collected, how the notification to be brought in, and all the state government has to follow that notification. Then sections 2, subject to the condition specified in the notification issued under the section A, where any proper officer issued an order under this act, he shall also issue an order under the Central Goods and Service Tax Act as authorized by the said act under the intimation to the jurisdictional officer of the central tax. Then B, where a proper officer under the Central Goods and Service Tax has initiated any proceeding on a subject matter, no proceeding shall be initiated by the proper officer under this act on the same subject. This is the power conferred by the Assam GST Act on the central government officer. Now, let's see CGST Act. Same provision is there. Section 6.
no, what do you want to say?
I want to say that in GST, 50% of the tax collected by the state, either state or the central, it goes 50% to the state and 50% to the central.
But in this case, state is not a party.
May not be party, but he was arrested under section 132. Same provision in a GST Act and CGST. Now let's come to section 6. And recently on 14th of August 2025, Supreme Court has decided on section 6 of the Central GST Act that the state as well as the central has similar power, and the proceeding initiated up to the so-called notice both the state and central can initiate the procedure.
What is section 6?
Section 6 of the CGST authorization of the officer of the state tax or union territory takes a proper officer in the certain circumstances. Let's say we have seen the AGST Act where the central government officers have been defined as a proper officer.
No, now what is your submission?
My submission
Your
is that-
submission is that since the tax which is alleged to have been
Yes, sir. Collected by-
evaded by the petitioner
Yes,
would have also gone to the state. Therefore, the
Yes, sir.
AG is not,
yes, Lordship, because there is a conflict of interest because the 50% of the tax goes to the state. Lordship, I prepared on note, Lordship, please to payroll tax.
what is the gist of that note? You may,
Yes, Lordship. This is the gist of the case.
what?
Regarding Lordship collection of tax and the role of the AG in defending the state or the central. In case of
No, your main objection to the appearance of AG is
the, yes,
that 50% would have gone to the
because there is a
state government. Therefore,
conflict of interest is there. Let's say we've seen how the tax is to be collected under section 2610 capital A. Under section 101 amendment, this provision was brought in and the act was passed. And let's see seen the section 6 of the AGST Act as well as the central act. Lordship, moreover, there is a notification of Governor of Assam with Finance Department, which clearly states that this is issued on 7th of September 2016 by the Finance Establishment Department of Government of Assam.
what it says,
Lordship, close 4. All letter may kindly be favorable.
yes.
In addition to the standing council, excluding those capacity of advocate general and additional advocate general of finance department are advised not to take up cases of other line department in the interest of the department.
Line department means other states,
Other
line
department,
department of
but
the state.
Here, Lordship, the situation is more, because here tax is collected on behalf of the, either by the by the state government or the central government, vice versa. And Lordship, in our affidavit, in paragraph. In affidavit, we have stated, he has created 7 farms. Out of that, about 4 farms has been registered with the state of Assam. That is also we have disclosed in our affidavit.
So the crux of your submission is,
Interest of the state is also involved in this case.
is it your submission that Advocate General cannot appear in any case under CGST,
Yes, sir.
any case
Yes, sir. Because interest of the state is also involved.
for the accused?
Yes, sir.
Okay.
Let's me please to see. Paragraph 3.3.4.
Of your
My
affidavit.
affidavit. During investigation, 9 farms were discovered to be fake farm. Lordship, serial number 2, it was registered in the state of Assam. State GST. Then serial number 4, 4, 5. 3 farms have been registered with the state of Assam.
No, I could not get this submission.
Lordship, here, the farm can be registered either with the central government or the state government.
Okay.
That doesn't make any difference. Ultimately, tax collected against each farms that goes to 50% to the state, 50% to the central government.
No, these are the firms
Yes, Lordship.
Which
Farm
are-
number 1 was registered with central government.
against which fake invoices were
Yes,
issued.
Yes, sir. And we have disclosed the amount also. And what is the status of Lordship at serial number 1? The date of registration and current status, 2923 cancelled, non-existent entity. Then number 2, which was registered with the state of Assam. It was suspended on 39/2023.
Similarly, farm number 4. It was a non-existent farm, but the registration was cancelled on 25/11/2024.
Okay.
This is my submission. Also. You also consider it. And regarding merit of the case, which is, I have regarding maintainability of the bail application, because it was filed under section 483. What's may come to 483. Bail application.
Yes. Yes.
483 of BNSA. Typical powers of the High Court of Session regarding granting bail. A High Court or Court of Session may direct that any person accused of an offence in custody be released on bail. And if the offence of the nature of the specified in subsection 3 of section 480 may be imposed. In paragraph 7 of the petition, it has been stated that page 7 of the bail application. Paragraph 7 of bail application, page 7.
Paragraph 7.
Page 7, paragraph 7.
Yes.
That the petitioner filed bail application before the Court of Chief Judicial Magistrate on 24/8/25, and hearing was done. However, the same being Sunday, the petition was not accepted by the court of the Honorable Chief Judicial Magistrate. The same was remained unnumbered, and no order whatsoever passed on the same, and the original petition was returned back to the petitioner. This is a statement to the petitioner. Lordship, I am relying on the judgment of our High Court of Division Bench. He says that paragraph 14. What more? Paragraph 14, paragraph 2.
Yes.
As
But-
far as the provision of section 439 are concerned, no option to choose the forum is given to the accused person, to the person accused, unlike under section 438. When a inferior court and the superior court are invested with the concurrent jurisdiction, normally a person or accused has to exhaust his remedy before the inferior court. If the person accused is aggrieved by the order of the inferior court, then he can approach the High Court, in which event the High Court will have the benefit of considering the reason and opinion given by the inferior court. The objective of investing concurrent jurisdiction in the Sessions Court and in the High Court is basically for the reason that the legislature repose trust in the wisdom of the session judge, who by their long-standing experience would have acquired and equipped with the necessary skills to exercise the power under the concurrent jurisdiction. The suitable and eligible session judge could also be elevated to the High Court. The objective of the investing concurrent jurisdiction is to share the serious responsibility and power of the High Court. For considering the bail application, a lot of miscellaneous work is to be done, like going through the case diary, remand application, statement of witnesses recorded, etc. Many a time, the investigating officer from different places of the state have to summon case diary and become a more time-consuming exercise. The Sessions Court, which are nearest to the police station, is the division where investigations are done. It's easy for the Sessions Court to summon the case diary and investigation paper from considering the bail application. Therefore, it is necessary that the Sessions Court, which is invested with the concurrent jurisdiction, could effectively deal with the all preliminary work of scrutiny of the investigation material while considering the bail application. In the event of rejection of the bail application by Sessions Court, a person accused can still move the High Court for grant of anticipatory bail under section 438 CRPC or bail application under 439 CRPC as the case may be. Now, Lordship may come to page paragraph 22. The conclusion, paragraph 22. it appears that the grave allegations are made in the complaint. The petitioner has filed an application without exhausting his remedy of filing an application before the sessions court. For the reasons stated above, it is just as necessary that the petitioner should exhaust his remedy before sessions court and then approach the high court. Accordingly, the petition is disposed.
Is it still a good law?
Yes, Lord. I check up, but I didn't find that this order was challenged before the Supreme.
No, but Supreme Court has given contrary observation in other cases. That if a person is in custody, he may approach even directly to High Court.
But in case of 438, anticipated bail, Lordship, that judgment is there, I find out. But regarding 439,
Okay, okay.
subject to correction, Lordship, I didn't find. I find the judgment of our High Court of Division Bench. Here, Lordship, all the judgment of Supreme Court has been taken into consideration.
We don't have the citation of it. It's not been given a copy.
Yes, 2015. The GLR 453.
Taylor.
GLR. So this is my preliminary objection regarding Lordship merit of the case. Case that is here, Lordship may tell this. All the provision of the Act law has been complied with.
Whether section 35(3) of BNSS is applicable.
Yes, Lordship. Because in Radhika Agarwal's case, Supreme Court says that GST Act is not in code in itself. We have to follow the provision of CRTC.
Okay,
Because it was pronounced in 2025 in the month of February. All the provision has been complied with, all the judgment has been complied.
okay, you give me the case diary.
Is it?
The case
Yes.
diary.
Yes, right.
Yes, miss.
We have trademarked the necessary laws.
So it is interesting to heard some new angle of arguments. In any case, I will address this honorable court. What is the role of the Advocate General? Today I am here as a senior counsel. Advocate General is appointed under Article 165, which my learned friend has just said. 165, what it says, let us go there. The governor of each state, not the president of the country.
Yes,
The governor of each state shall appoint a person who is qualified to be appointed as a judge of a high court to be Advocate General for the state, not for the nation. So these are very fundamental differences, which has a big ramification. It shall be the duty of the Advocate General to give advice to the government of the state, not the government of the nation, upon such legal matters and to perform such other duties of a legal character as may from time to time be referred to or assigned to him by the governor. So whether the governor of Assam can assign me a work under CGST, the result is big no. And to discharge the function conferred on him and or under this constitution or any other laws for the time being in force. So the governor of Assam has no jurisdiction to engage me for a matter relating to the central government. I'm giving an example. I'm appearing in 4 or 5 cases on behalf of NIA, National Investigating Agency. I think I have appeared before Lordship also. A separate appointment order has been issued to me to appear on behalf of NIA. If I am the Advocate General, I should get an automatic entry
as senior counsel.
as senior counsel. So this is the basic fundamental difference. So whatever role I have to play, it is within the domain of the state government. The funding, all these things are not criteria at all. These are not parameters. I am appearing regularly in income tax matters. 42% of the income tax comes to the state. My learned friend is saying I'm not disputing, or maybe I do not know the exact proposal, exact quantification, what amount of CGST comes to the state government. Every fund, I am appearing in case of central excise, where the central government is the authority who is collecting the fund. I am appearing in case of customs against the central government. I can appear, I mean, at the Advocate General. as a senior counsel, not as a advocate general of the state. So there is absolutely no bar. So it shall be the duty of the AG to give advice to the government of the state, that means Assam government, upon such legal matters and to perform such other duties of a legal character as may be from time to time be referred to or assigned to him by the governor, and to discharge the functions conferred on him by or under this constitution or any other laws for the time being in force. The Advocate General shall hold the office during the pleasure of the governor and shall receive remuneration from the governor as determined. So it is plain and simple. There is no ambiguity. If I have to elaborate on this, there are a series of judgments. Now, a 5 judges constitution bench in the year 1965,
Petition.
DC Hingorani versus GP Mishra. I am giving a copy. So Lordship will have to look it from the perspective of whether the Advocate General as senior counsel can appear in as a defense counsel in any criminal matters.
Yes.
That is the core question. If we look at the history of our case, a very reputed senior counsel, JP Bhattacharya. He was the Advocate General of one of the state at that point of time. A CBI case was registered against one of the minister's family of Nagaland. He appeared in that case as defense counsel. So that is the beginning. Thereafter, the counsel, the Advocate General of Nagaland and Arunachal Pradesh regularly appeared before the criminal cases in the principal seat of Guwahati High Court. One of the honorable judges raised an objection, my Lord Justice H. N. Sharma, and Niloy Dutta was the Advocate General of one of the state. Raised an objection that he cannot appear before the in a criminal proceedings. Niloy Dutta, who is unfortunately not with us, he wrote to the Bar Council of India, and Bar Council issued a clarification. There is no bar in respect of an Advocate General in appearing as a defense counsel in a case where his state is not involved. These are in public domain, all these things. Thereafter also, some of my learned friends who are Advocate Generals of various states at present also, they are appearing regularly in criminal cases in the principal seat. So there is absolutely no issues when this Attorney General, not Attorney General, the Solicitor General in 2015 appeared for some bar means the liquor bar cases on behalf of some association of Kerala, and a PIL was lodged in the Supreme Court. And that case was dismissed in limine. This is the report. AG can appear for private parties so long as there is no conflict of interest, the Supreme Court said. This is a one-liner judgment, but the core issue is it was widely reported in 2015. And now, two important cases I would like to refer to. One is TC Hingorani versus GP Mishra. It's a 5 judges constitution bench of the Supreme Court in the year 1965. The judgment was delivered on 24th September 1965. Lordship may take up that paragraph 4.
Yes. Yes.
I am reading from paragraph 3. The position, status, and duties of the Advocate General are to be found primarily in Article 165 of the Constitution. Article 165(1) provides that the governor of each state shall appoint a person who is qualified to be appointed as a judge of the High Court to be Advocate General for the state. Having thus specified the qualification for appointment as Advocate General, Article 165(2) prescribes his duties. It provides that it shall be the duty of the Advocate General to give advice to the government of the state upon such legal matters and to perform such other duties as of a legal character as may from time to time be referred or assigned to him by the governor. So the governor has not assigned me any work under CGST. It is as simple as that. And to discharge the functions conferred on him by or under his constitution or any other law for the time being in force. So the governor does not have the authority also to assign me any work under CGST. It is beyond his jurisdiction. So my role is very limited as Advocate General within the state and within the laws, within the parameters and within the periphery. Nothing beyond that the governor can give me. So if he does not have the authority to engage the Advocate General for a central government case, the central government will have to engage me, whether his department is engaging me or not. In NIA, they have engaged me. So it is well demarcated. May I read further? Article 165(3) provides that the Advocate General shall hold the office during the pleasure of the governor and shall receive such remuneration as the governor may determine. It is thus clear that the Advocate General has to give advice to the government of the state. Lordship will again mark this, government of the state has in performed such other duties as the legal character may be assigned to him by the governor, or has to discharge other functions conferred on him by the provisions of the Constitution or any other law in force. Therefore, there can be no doubt that if the state government assigns the Advocate General the work of appearing in any legal proceedings in which it is interested, it would be the assignment to perform a duty of legal character within the meaning of Article 165(2). And in assigning such duties, the state government would be acting within its jurisdiction. So that jurisdiction part is very important here. The state government or the governor cannot proceed beyond the jurisdiction of the state of Assam. And in accepting the assignment, the Advocate General will be discharging his duty imposed by the said provision. Then as to his status as advocate simpliciter. So what I am doing here, I am taking the role of an advocate simpliciter. He was entitled at the relevant time to practice as a matter of right as prescribed by Section 14 of the Indian Bar Council Act. So what I am doing now, not under Constitution. I am working, I am discharging my duty to my client in this particular case under Indian Bar Council Act 1926, which was subsequently amended in 1964. It is not disputed that the Advocate General is not a government servant, though he receives remunerations for his appointment as Advocate General under Article 165(3). So this department, which my learned friend is saying, line department, etc., that restriction does not come upon me. And so there can be no doubt that subject to the other terms and conditions of his appointment as Advocate General, he would be entitled to exercise his fight as an advocate and appear for private parties. So the private parties cases, there is no distinction whether it is income tax case, whether it is other criminal case, whether it is central excise case, whether it is a public sector enterprises case, whether it is a corporate matter. All these things comes under private practice. Thus, whether the status of Mr. Mishra is considered as an Advocate General or as an advocate, prima facie, it is difficult to understand how he can be prohibited from appearing in any legal proceedings like the one in which the Allahabad High Court was dealing at the present case. The legal remembrances manual prepared by the Uttar Pradesh government provides that for certain rules for the conduct of the Advocate General, the government advocate of the High Court, the deputy government advocate, the assistant government advocate, the senior standing counsel, and the junior standing counsel. The appointment of the Advocate General, however, is made under the constitutional provisions contained in Article 165, and that gives him a special constitutional status. The judgment under appeal indicates that the Allahabad High Court based its decision inter alia on some of the rules made by the UP government for regulating the conduct of the Advocate General and the government advocate for the High Court. These rules are not statutory rules. They are rules made by the state government for the guidance of its law officers. It is necessary to refer to the relevant rules before considering the correctness or propriety of the view taken by the High Court on the strength of these rules. So these rules are not very relevant because my whole as Advocate General is governed by Article 165. So these rules also supports the Advocate General to appear for private cases.
Whether for the state of Assam, are there any such rules?
We do not have rules.
Okay.
We have no such rules.
Okay.
My learned friend who have otherwise placed those rules. There is no such rules. And on top of that, I have verified if I take the consent, I can appear in other cases also. So far this case is concerned also, I have taken the consent of the state government. Not only this, for appearing in some cases against CBI, I am appearing. I have taken the consent. So there is absolutely no conflict with the state government. My friend have a conflict with me, but the state government does not have a conflict with me.
I have no personal.
No, I'm giving an example. What I'm saying, I mean his client, no, he's taking it personally. No, it is not personal.
I'm not taking personally.
Then the CGST may have a conflict with me,
Yes. This is
but
my-
not the state of Assam. The state of Assam, who is my employer, they do not have any objection to my appearing. My employer is my government, the state of Assam, not the department which my learned friend is holding the brief. So there is absolutely no doubt about this.
Okay.
So if Lordship wants to hear further, I can go and elaborate the whole
No,
judgment.
no, because it deals with the rules of UP.
That is not relevant here. That is why. But that is also in support of the Advocate General.
Okay.
If Lord, let me place it. Now, paragraph 6, Rule 8 provides.
What is the final outcome of
The
this?
final outcome is paragraph 4, which I have just placed. The final, whether the status of Mr. is considered as an advocate or an advocate, prima facie, it is difficult to understand how he can be prohibited from appearing in any legal proceedings like the one in
So,
which
so this judgment says
that he can appear.
Appear where there is
The state government is not in.
not a party. Okay.
There is another very famous case, that citation I could not, but it was public domain again. That is Allahabad High Court in Sardar Pratap Singh Kairon's Enquiry Commission case, where the Advocate General Punjab appeared for an accused person in criminal proceedings in Uttar Pradesh. The division bench of Allahabad High Court ruled that there is no bar for AG Punjab to be a defense counsel in a criminal case in UP, another state, as he is not the state law officer in UP.
Yes.
On writing. But that judgment I could not find out. If required, I can find it out. That Allahabad High Court in Sardar Pratap Singh Kairon's Enquiry Commission case. So the AG Punjab appeared in UP for the accused.
Facts are distinguishable
Sorry.
in that case which you are referring. Punjab AG appeared in a UP case.
Here, the Assam AG appearing in a central government case.
Yes.
So it is much more.
Okay.
So where Punjab is not a party, here Assam is not a party to the central government.
Okay.
I am fighting some cases where we have issues with royalty of the oil against the central government. In oil sector, we are getting huge royalties. The central government is not giving us that royalty. So I am fighting a case for the state of Assam against central government for our claim of royalty. And one such case is still pending in the Supreme Court, where also I am appearing. So this funding issue, that cannot be a criteria to say whether the Advocate General can appear in a particular case or not. So that cannot be a criteria. None of these criteria has been indicated or whispered in Article 165. Article 165 says that he will advise the government and he will conduct the cases of the state for the matters related to the state. So, Bar Council clarified that Advocate General can appear in a case where there is no conflict of interest. In this, Lordship may have a look at this. This issue was raised politically 10 years ago. Just have it. And all the newspapers.
Okay, his main objection to your appearance is that
Funding.
the tax which is evaded by the petitioner, 50% of it would
Has
have
come.
gone to state.
Whether that can be a criteria.
Therefore, he's saying that there is a conflict of interest.
Whether then every case, I cannot appear before any case against airport authority also. I cannot appear any case against NF Railways also. That is not the idea, Lordship.
Okay.
Affair of the state. He can stretch his imagination to every level. He can take it to the moon also. He can take it to the space also. But that is not circumscribed by the Constitution, Article 165. Article 165 limited the jurisdiction in which the Advocate General can appear.
Okay, I will address this in the
Lordship.
order.
So if Lordship allows, then I can go ahead.
Yes.
Yes, deeply obliged. But I will take back that paper because that paper.
Tentatively, I am allowing, because the petitioner's case has to be decided. This is a bail matter.
My lordship, correct.
Now, whether he can appear in such cases or not, I will address this in my order,
I just supplement to my learned friend.
because he has already made his submission yesterday. You have already made.
Yes, but today I'll place the laws which covers the bail case.
Regarding the Advocate appearance in other state cases and other cases, I don't have evidence. But yet the lordship in GST cases, lordship has seen the scheme, Article 269 capital A. Then I placed section 6. Lordship recently, Supreme Court, while deciding section 6(2), whether state, central or state is concurrent jurisdiction. Lordship paragraph 96, I placed the judgment. I'm reading slowly for benefit of all. Conclusion, this was decided on 14/8/2025. The party name is Armored Security India Limited
No,
versus Commissioner.
What it says in,
It says that both the center and the state has concurrent jurisdiction in case of GST. Apparently there is a conflict of interest in case of GST matter. So other matter, lordship, my learned friend is correct. He can appear all the we have seen, my senior also, while he was a Advocate General of Meghalaya, he used to appear in the state of Assam also cases. So there is no bar, but this is a special act law.
Yes.
This is my submission law. Then while deciding section 6(2), Supreme Court made observation. We summarize our final conclusions as under clause B of subsection.
which judgment you are reading?
This is the party's name is Armored Security India Limited versus Commissioner of GST, Delhi State, Delhi is Commissionerate and others. This decided on 14/8/2025. Unfortunately, I don't have one copy. I'm reading and I'll supply copy to you. Conclusion. We summarize our final conclusions under 1. Clause B of subsection 2 of section 6 of CGSTL. Equivalent state enactments bar the initiation of any proceeding on the same subject matter. Then 2. Any action arising from the audit, account or detailed scrutiny of the return must be initiated by the tax administration to which the taxpayer is assigned. Here, lordship, in paragraph 3.3, we have said that out of 9 farms, 3 were registered before the state of Assam. And rest were registered in the central government portal. Then paragraph 3, intelligence-based information action can be initiated by any of the central or the state tax administration despite the taxpayers having been assigned to the other administration. Here, lordship, BGGI is making investigation in both the cases where the accused has been registered with state or the central laws. Okay, Supreme Court clarifies. Then paragraph 4, parallel proceedings should not be initiated by the tax administration when one of the tax administration has already initiated intelligence-based information action. Then paragraph 5, all the actions
You
that are
mark those paragraphs.
Okay.
Mark those paragraphs.
No, paragraph 96 and 97. So my submission before your lordship is that when the state, central and state has concurrent jurisdiction over a issue, in that case, lordship, there is a conflict of interest. Here we are collecting, he evaded tax about 28 crores. That is to be divided 50% between the state and the central. And in my lot, I clarified, if I learned and admit that in spite of that provision, he can appear. I have no personal objection against my learned friend's agreement. Definitely being senior advocate, he can appear in any case. But in case of GST lordship, I have objection. And this scheme of the act says that when the tax is divided among the petitioner at 50% by the state and the central, there is a conflict of interest, lordship. Lordship, when we goes to any shop, when you get a memo, lordship sees that in the bottom, the tax is divided. If it is 18%, they are charging 18%. 9% charges on behalf of the state tax, and the rest 9% for the central. It is evident on the face of the record, Lordship, and 269 capital A clearly stated this. And Lordship, all the provisions of the Assam State GST Act and Central GST Act are similar, Lordship. And in section 6, I have placed before a
No,
Lordship.
who is the prosecuting agency?
Lordship, we are the central government
Central government is
on behalf of the state, because Lordship, any tax collected, that will be divided among the state and the central. Lordship, please to see section 132 of the GST and central government. Same, Lordship. And Lordship, any notification issued by the central government that were adopted by the central government. Here, Lordship, one petition is pending, where section 16 AA has been put under challenge. That was of the state, Assam State GST Act, Lordship. Here, Lordship, the state government has stated that we are adopting the affidavit filed by the central government, and the central government defends that. Because the provision is same. Here, Lordship, in one case, that was relating to state GST. Lordship, that notification 9 and 56 was challenged. My learned friend was the petition in that case, Lordship. The junior counsel to my learned senior. And that case, Lordship, this honorable court, here the central government also. And that notification was set aside. 9 was upheld. And 50, thereafter the central government had challenged in the writ petition that judgment. So concurrent jurisdiction is there, concurrent finding is there. So my objection to that, regarding other point, I have no objection. He can appear in any case also. But here, when there is a conflict of interest.
Oh, okay, I'll address these issues.
Regarding merit of committee, my learned friend.
Yes, what you want to add to regarding merit, not on your appearance, that
No appearance, only thing. For the other part, there's a specific act that is called Assam Goods and Service Tax Act. So in that case, there's a different cause of action, different mechanism, different machinery. My learned friend is trying to confuse this honorable court. So there is one domain which is governed by the State Goods and Service Tax Act. And the other domain is central government. So when state has no authority to enter or include into the area of CGST.
in this
Vice versa.
Assam Goods and Service Tax Act, are there any penal provisions
Yes, yes,
in this case?
yes, yes.
So if,
In this case, no.
no,
There are
my
separate.
query is in Central GST Act.
There are penal
pro-
provisions. In
penal
Assam also
provision-
there are penal provisions.
Penal provisions are
There are
there,
penal
and
provisions. And this-
prosecuting agency in CGST is
separate
central
agencies.
government.
Separate agencies.
And in this Assam Goods and Service Tax Act, the prosecuting agency is the state government.
State government.
Okay.
Totally separate, segregated. These are not supplement to each other. And Article 165 starts with it is not starting with a non-obstinate clause, or there is no subject to any other clauses or article of the Constitution. It is an exclusive clause on its own. If the appointment of the Advocate General is subject to the other articles which my learned friends placed regarding devolution of fund, then consolidated fund, all these provisions my learned friend has sold. It is not subject to any other provisions of the Constitution. So it is an exclusive and stand-alone provision. So the AG of a state is appointed under Article 165(1). His role is defined under Article 165(2). So there is no other conditions or preconditions here.
Okay.
And if anybody have to raise a conflict of interest, that conflict of interest have to be raised by my employer. The state AGST authority, if they have raised an objection, Lordship would have entertained that. Not the CGST. How can they say that there is a conflict of interest? The conflict of interest would have caused detrimental effect to the AGST or the Assam government, then Assam government would have raised this issue. He does not have the locus to raise this issue. In any case, Lordship, that is my submission. So Lordship is allowing me to continue. So let me now place the case. Here, Lordship will see. My argument will be on various points. So I'll place my case on the basis of 9 points. First point is that the case is totally based on documentary evidence. All the documents, whatever they wanted, they have not asked me any documents. If Lordship is pleased to look at the summon, page 22. So this gentleman, Olokesh Day, while I'm making the inquiry in connection of GST investigation, with issuance of fake tax invoices of coal coke without actual supply, and under CGST Act 2017, and whereas I consider your attendance necessary to give evidence and or to produce documents or things of the following descriptions in your possession or under your control. So he said that to depose verbally and in writing.
Yes.
So other things he have not said. So he wanted my appearance and give statements which they have already recorded as per their affidavit today at 2 o'clock on that day. Last paragraph, inquiry as aforesaid is deemed to be in judicial proceedings within the meaning of section 229 and 267 of Bharatiya Nyaya Samhita, and non-compliance of this summon is an offense punishable under so and so. So they basically wanted my appearance. They have already seized. If Lordship is pleased to come to the Panchnama.
Page.
Panchnama is here. Yes. It starts from page 17. Lordship will kindly, therefore, in exercise of middle portion, therefore, in exercise of the power conferred upon me under subsection 2 of section 67, I hereby seize the following goods, books, documents, and things. Details of goods seized, nil. Details of books, documents, things seized, annexer A. They have already seized everything. And Lordship will see what they have seized, annexer A.
Laptop and
And mobile. So there is no documents further in my possession, according to them itself. They have not asked me to produce any documents also in the summon. They wanted my appearance only. And during the search operation and the seizure operation, I have fully cooperated. Whatever they have asked, I have very willingly, I have disclosed. Next day, they called me for the personal appearance. I appeared without any objection. Then they have one very important, Lordship, during this hearing, Lordship has raised this issue, whether they have issued that notice, which was identical to section 41 of the earlier act. Now it is 37, 35. That notice to arrest, 35, which says, I'll place Supreme Court judgment as well as other High Court judgment. This is mandatory. The period of my total conviction is 5 years. That is the maximum conviction time. So as it is below 7 years, by following the principles in Ernest Kumar and another case, Lordship, they are bound to give me this notice, section 35's notice, under the BNSS. Section 35. When police may arrest without warrant. Any police officer may, without an order from magistrate or without warrant, arrest any person who commits
What is section 70 of CGST Act?
CGST notice. Section 70 says, power to summon persons to give evidence and produce documents. So this is not to arrest.
Okay.
There is a fundamental difference here. Section 35 says power to arrest without warrant. Here it is power to summon, which they have issued, and I appeared and they took my statements.
So in this case, 35(3) notice was not
issued. This is a blatant mistake they have committed.
And whether any reasons
No.
have been shown?
No, I'm going to read everything. And Supreme Court and some other High Court, their whole exercise starts from issuing the notice, arrest, and thereafter no trial. That is the trend observed by various courts. Up to arrest, up to detention, they take full interest, and thereafter there is no completion of the investigation. Here also they have flouted this norm. So Lordship will kindly come to page 24 now. Authorization to arrest, reasons to believe. Whether these reasons to believe, which they have incorporated here, fulfills the requirement as laid down by the Honorable Supreme Court in that Agarwala's case.
Yes.
Authorization to arrest, reasons to believe. Investigation has revealed that Gaurav Agarwal, aged about 40 years, so and so, is a part of syndicate. So they have to identify who are my partners in the syndicate, which provides fake invoices and e-way bills to certain suppliers of coal. These fake invoices and e-way bills are generated in the name of following unknown, unrelated business entities. Evidence, including his voluntary statement, WhatsApp chat, has revealed that the above fake invoices and e-way bills have been used by the syndicate to supply coal without payment of GST, as this supply has not been declared in the GST returns, leading to evasion of GST of 28.95 crores during the period March 2023 to May 2025, as given below. So these are the entities' name. There is no documents they have indicated here. Next, thus he has committed an offense under section 132(1)(a) of the CGST Act, which is punishable under section 131(1)(1) of the CGST Act, and is a cognizable and non-bailable offense under section 132(5) of the CGST Act. Investigation is still at initial stage. He has not divulged all the details about the syndicate and certain crucial facts, information related to GST evasion. Thus, his custodial interrogation, which is elicitation oriented, is absolutely necessary in this case. This is a need. There is a need to cover other associate persons, brokers, coal suppliers, and other associate involved in the GST evasion. At this stage of investigation, there is a possibility that he may influence witness, tamper the evidence, and scuttle the ongoing investigation. Additionally, his physical presence is also required for timely completion of investigation. Thus, I am of the considered opinion that Sri Gaurav Agarwal is to be arrested to ensure fair investigation. Therefore, I exercise authority granted under section 69 of the CGST Act and authorize Sri Om Prakash Intelligence Officer to arrest Sri Gaurav Agarwal. So whether these reasons to believe is sufficient in the eye of law, that Lordship will have to examine. I will place the Supreme Court judgment on this. Whether all the parameters, how this conclusion they have come, and what are the details which is required to form these reasons to believe opinion are there or not. If it is not there, then this arrest is illegal. If it is there, it is legal. Then ground of arrest, they have said that I am a part of syndicate which provides fake invoices to enable supply of coal from Assam to Bihar without payment of GST, including coal. You provide fake invoices in the name of non-related fake firms to those coal traders. These fake firms issue e-way
No,
bills.
47 notice you are not challenging.
Lordship,
You are not challenging 47 notice.
this is ground of arrest.
No, but you are not challenging that there is some illegality. Or are you challenging it?
I'm just verifying it in the repeat.
Your main plea is that reasons for arrest, reasons for dispensing with 35(3) notice are not supported by facts.
That is a legal argument I am making, Lordship. But what we have said, our detention, basically we are praying for release on bail. That is our prayer. But these are the grounds. So grounds we don't have to challenge. The grounds I am citing, but what is our ultimate aim? Prayer, Lordship will kindly come to page 14. It is therefore prayed that your honor would graciously be pleased to admit this petition, call for records and perusal thereof, may be pleased to allow the petitioner's name to go on bail in connection with so and so. So these are the grounds I am citing, Lordship. For every thing, we don't have to put it in the prayer, in my humble submission and understanding. I may be wrong.
No, I'm not on that. You are seeking bail mainly on ground that your arrest was not necessary, as you have cooperated. That is one ground.
That is one ground.
Second ground
There
is.
is no chance of my flight risk.
Yes,
I'm not
and
absconding.
you are also pressing on the ground that this being a case where punishment is up to 5 years, the requirement of issuance of notice under section 35(3) was
not complied with,
there, but it has not been complied with.
Lordship.
And the reasons shown by the arresting authority for dispensing with the notice are not valid reasons.
They have not said anything.
Okay.
They have not said. They are silent on this. Why they have dispensed with, my learned friend will definitely make, but I could not find any whisper about this notice.
Okay.
So according to them, it is not required. But according to the Supreme Court, as this honorable court also, it is a mandatory condition. If the arrest is to be made for an offense where the punishment is below 7 years, I'll place that judgment. So today, actually, I'll take some time, Lord.
How much time?
Yeah, because I have 4 or 5. If Lordship wants to take it in the second of, I have already.
No,
because it will take some time.
you finish it within 15 minutes.
15 minutes. Oh, fine, Lordship. I'll try to.
Yes.
Give me half an hour, Lordship. In half an hour, I'll finish.
Let us see how much
Lordship.
time it takes.
So, then another ground is that it is basically the whole case is based on documentary evidence. They have already seized whatever is with me.
Yes.
My further detention is not required.
That you have submitted.
Yes. Then I am fully cooperating. Departmental detention is not required. Reasons to believe there is a flaw that I'll try to convince its owner from the judgment. Then section 35 note. Identical cases, this honorable court and other courts also granted bail. In fact, 3 persons they have named in their affidavit. If Lordship is pleased to take the affidavit filed today. Yes. Paragraph 3.3.3. It will be internal page. No, it is page 43.
Yes.
The fake invoices issued in the name of various firms along with corresponding e-bills were arranged by him through Sri Binod Agarwal, Paranjit Mandal, and Subham. I am 100% confident Binod Agarwal and Subham Jain got their bail on the very first day. The middle person I do not know, but the other side can definitely enlighten this honorable court. So they are already granted bail, and one I think by the magistrate court itself. So let me now the facts. I think Lordship has already seen everything. And Lordship, one more thing, page 29
Of your petition.
of my petition, Lordship. 24/8/2025. They also wanted that I should be sent to judicial custody. May I read it, Lordship? Accused Gaurav Agarwal is produced before me after completion of 4 days of departmental police custody. The medical report reflects, etc. An application under 132(5) of the CGST filed by Sushil Kumar Meena, intelligence officer of goods, praying for judicial custody of the accused for 15 days. So they are not requesting for their own custody also.
Okay.
And today I have come to know that they want they want to take some statement tomorrow from 2 to 4 p.m. in my jail. If Lordship please to grant me bails in case I can go and appear also, because I am not running away from day one itself. So that cannot be a ground for further detention. If they want any time, all times to come, I can always cooperate with them. Now, let me place the judgments. Agarwal to Supreme Court judgment. Radhika. Predicate put in. हाँ। नहीं मोटा मोटा वाला कहाँ गया मेरा मोटा वाला एक कुछ बोल तुम डांगर को कर दो নহয় ৰাতিটো वाला এখন নেকি हाँ ইয়াতে আছে it is reported 2025 Supreme Court cases online Supreme Court 449 3 judges bench of the Honorable Supreme Court.
Which para?
Paragraph Lordship, it will start from paragraph 49 onwards.
On what point this?
On the point of what should be there in there are various, all the provisions were discussed here. What I am trying to emphasize because of paucity of time, otherwise I have placed everything. The point on no materials visible, page paragraph 59. Lordship, let me place from paragraph 56.
Yes.
It is clear from the aforesaid provisions that to pass an order in arrest in case of cognizable and non-cognizable offense, the commissioner must satisfactorily show. This is regarding this formation of opinion under CGST Act. The commissioner must satisfactorily show by the reasons to believe recorded by him that the person to be arrested has committed a non-bailable offense and that the preconditions of subsection 5 of section 135 of the Act are satisfied. Failure to do so results in an illegal arrest. With regard to the submission made on behalf of the revenue, the arrests are not made in case of bailable offense. In our considered view, the commissioner, while recording the reasons to believe, should state his satisfaction and refer to the materials forming the basis of his findings. So there is absolutely no materials here. Total absence of materials. Regarding the commission of a non-bailable offense specified in clause A to D of subsection 1 of section 132. The computation of the tax involved in terms of monetary limits under clause 1 of subsection 1, which makes the offense cognizable and non-bailable, should be supported by referring to relevant and sufficient materials. He says, I may abscond, I may tamper with the investigation. Where is the materials? The aforesaid exercise should be undertaken in right earnest and objectively, and not on mere ipsi dixi without foundational reasoning and materials. The arrest must proceed on the belief supported by reasons relying on materials that the conditions specified in subsection 5 of section 132 are satisfied, and not on suspicion alone. An arrest cannot be made on merely investigate whether the conditions are being met. The arrest is to be made on the formulation of the opinion by the commissioner, which is to duly recorded in the reasons to believe. The reasons to believe must be based on evidence establishing to the satisfaction of the commissioner that the requirement of subsection 5 of section 132 are met. If we look at that page, there is absolutely no indication, no details. Next page, Lordship. Our attention was drawn to the judgment of the High Court of Delhi in Make My Trip case, which is the decision interpreting the power to arrest under Finance Act 1994. These provisions are related to service tax, excise duty, service tax, and other taxes are subsumed by the GST regime. Accordingly, we are in the agreement with the findings recorded in this decision to the extent that the power to arrest should be used with great circumspection and not casually. Further, as in the case of service tax, the power to arrest is not to be used on mere suspicion or doubt or even investigation when the condition of subsection 5 of section 132 of the GST Acts are not satisfied. However, relying on the judgment in the Make My Trip case, it has been submitted on behalf of the petitioner that the power under subsection 5 of section 132 cannot be exercised unless the procedure under section 73 of the GST Act is completed and an assessment order is passed quantifying the tax evaded or erroneously refunded or input case tax credit wrongly availed. According to us, this contention should not be accepted as a general or broad proposition, we would accept that normally the assessment proceedings would quantify the amount of tax evaded, etc. And to go on and to show whether there is any violation of the terms of A to B of subsection 1 of section 132 of the GST Act, and the clause 1 of the subsection 1 is attractive. But there could be cases where even without a formal order of assessment, the department revenue in certain cases, it is a case of offense under clause so and so of 132, and the amount of tax evaded, etc., falls within clause 1 of subsection 1 of 32 of the GST with sufficient degree of certainty. In such cases, the commissioner may authorize arrest when he is able to ascertain and record reasons to believe. As indicated above, the reasons to believe must be explicit and refer to the materials and evidence underlying such opinions. So assessment may not be required or in certain situations, but there should be availability of materials and evidence underlying such opinions.
What is 132.5 of GST?
132.5 where they can arrest. Other cases is all bailable.
Please read.
132.5. The offenses specified in clause A or clause B or clause C or clause D of subsection 1 and punishable with clause 1 of the substance shall be cognizable and non-bailable. So ABCD, that this invoice, etc., supply any goods or services both without issue of any invoice. This is 1. B says issue of invoice
Okay.
or bill without supply of goods. So these are the 4 situations. And where with proper materials, he can form an opinion. He will have to form an opinion. Materials, plan, evidences. Normally, the situation is that assessment should be over. But in certain situations, without assessment also, that is in favor of the officials, that without assessment also they can form an opinion subject to the condition that there are sufficient materials and evidence underlying to form such an opinion. There has to be a degree of certainty to establish that the offense is committed and that such offense is non-bailable. The principle of benefit of doubt, these 4 lines of the paragraph is important. The principle of benefit of doubt would equally be applicable and should not be ignored either by the commissioner or by the magistrate when the accused is produced before the magistrate. So now when they say that I am a part of a syndicate, what are the other parts? What are the other members of that syndicate? There is no indication. They have to give details of each of the invoice which they think that supply was not made. Where is the materials to show that these are the documents against which no supply was made? Number 3, where are the consignments details? Which are the consignments against which the supply was not made? Only on record the materials are there. These are the 3 vital areas. There is total ignorance, total absence, and absolutely no indication of the materials. Without those materials, it is absolutely impossible to form a objective opinion. Subjective opinion, he can think anything, just like they want that Advocate General cannot appear. That kind of opinion they can always make. But on the basis of 165, whether that opinion can be formed. So they have to form an opinion on the basis of evidence. So in the absence of evidence, in the absence of materials, that reasons to believe cannot be formed in my humble submission. Mere conjecture, mere suspicion will not be sufficient, will not suffice to come to a conclusion to arrest. That is why the Supreme Court in this judgment very clearly says this will be otherwise this will be abused. Because in all other situations, the offense is bailable. Only in this situation, it is a non-bailable where the liberty will be curtailed of a person. So this is on this point. All other points are covered here. If Lordship may go through this judgment from paragraph 47, 48, 50. I have read 61, 62. Up to 65. As Lordship is giving me 15 minutes, I'll try to curtail my submission. 2 more judgments I would like to place. One is of Punjab, Punjab, and one is of Bombay. And one of Lordship judgment. And one of another High Bombay wala de diye. Bombay to diye. The court of diye. 2024 SCC online Bombay 262. Rahul versus Director General of Goods and Service Taxes Intelligence, Nagpur branch.
Yeah.
Here, paragraph, basically the facts are from paragraph 1 to 5, 6 also. Paragraph 8, they said that this section 35 notice is not required. Ultimately, the Supreme Court said, the Bombay High Court says paragraph 17. Applicability of this section 35 notice, paragraph 17.
What it says that it is required.
The contention of the additional Solicitor General that the petitioner cannot take umbrage under section 41 and 41A may not be correct.
Okay.
Then paragraph 18 describes the reasons to be recorded. May I read it? It is further held that the Honorable Apex Court that it may be remembered in section 41C of the Code of Criminal Code does not provide an absolute irrevocable guarantee against arrest. Despite the compliance with the notices of appearance, the police officer himself is entitled under section 41A3 Code of Criminal Procedure for reasons to be recorded, arrest a person. At this stage, we may notice that the difference in language between section 41A3 of the Code of Criminal Procedure and 69(1) of the CGST Act 2017. Under section 41A3 of the Code of Criminal Procedure, reasons to be recorded once the police officer is to be of the opinion that the person concerned ought to be arrested. In contrast, in 69(1 uses the phrase reasons to believe. So reasons to be recorded, it is not sufficient. Here, it is one step further. In contrast, section 69(1 uses the phrase reasons to believe. There is a vast difference between reasons to be recorded and reasons to believe. Then these are elaborated. I do not want to take much time. Paragraph 27. As noticed above, in view of section 69 of the CGST Act 2017, the commissioner may authorize arrest of a person only if he has reasons to believe that such a person has committed any offense under the clauses mentioned herein. Reasons to believe does not mean a purely subjective satisfaction. It contemplates the existence of reasons on which the belief is founded and not merely a belief in the existence of reasons inducing the belief. The belief must not be based on mere suspicion. It must be founded upon information. Such reasons to believe can be formed on the basis of direct or circumstantial evidence. A rational connection postulates that there must be a direct nexus or live link between the materials coming to the notice of the officer and the formation of the belief. Paragraph 29. In the case of Ernest Kumar versus Bihar, the Honorable Apex Court, while laying down some guidelines, clarified the direction issued would not only be applicable to cases under 498A or Section 4 of the Dowry Act, but also cover cases where offenses is punishable with imprisonment of for a term less than 7 years, which may extend to 7 years whether with or without fine. The Honorable Apex Court in Satinder Kumar's Antil versus CBI has reiterated the above principles in paragraph so and so. This is what is stated there. Paragraph 31. The submission made by the learned counsel for the non-applicant that the observations for restricting on only if the police officer may not apply the officers of CGST department exercising power of arrest under the CGST Act may not hold any water, as whatever may be statute under which the particular to an offense arrest indisputably would result in the same consequences. The guidelines issued by the Honorable Apex Court are to be followed in the backdrop of severe congestion in the jail, and the denial of the bail is an exception where the custody for the purpose of investigation is not warranted. There is no reason why the aforesaid guidelines shall not be made applicable to the statute like in the present matter, where the power is conferred upon an officer to effect an arrest in case of offenses where the penalty prescribed is less than 7 years of imprisonment. The power to arrest, which is under section 69 of the CGST Act 2017, contemplates a rider in the form of the commissioner having reasons to believe that the person has committed the offense specified in clause A to D of subsection 1 of 132, or he may authorize any officer of the state to arrest such person. So considering the scheme contained in section 132 of the CGST and after taking into account the punishment provided, the decision of the case of Ernest Kumar of Bihar Supra was extensively reproduced in the case of Daulat Subarmal Mehta and the secretary, which is reproduced here. That is the same thing. The requirement under subsection 1 of section 69 is reasons to believe that not only a person has committed any offense as specified, but also as to why such persons needs to be arrested. From a perusal of the reasons recorded by the Principal Judicial Director General, we find that other than paraphrasing the requirement of section 41 CRPC, no concrete incident has been mentioned therein recording any act of tampering of evidence by the petitioner or threatening, inducing any witness besides not cooperating with the investigation, not to speak of fleeing from investigation. In such circumstances, we are of the view that the Principal Additional Director General could not have formed a reasons to believe that the petitioner should be arrested. In the light of above observation, where facts of the present case are taken into consideration, it reveals that the applicant was arrested, necessary investigation is carried out, and the statements of the applicant is also recorded. The maximum punishment provided for imprisonment up to 5 years. The fact of the case shows that the dispute is regarding the tax evasion and the applicant has already paid 81 lakhs towards the said tax amount. The offense is under the CGST Act except with the limited exception of the compoundable. In the light of above, the detention of the applicant in jail is not required. The applicant is not involved in any heinous crime like murder or terrorism. The basic rule is bail is rule and jail is exception. The allegations of serious financial impropriety are leveled against the applicant. Therefore, in view of above, further insertion of the applicant is not required. Accordingly, I proceed to pass the following. The bail was granted. And Justice Ujjal Bhuya's also judgment is there from Mumbai High Court. Mahesh Kumar. Here also, video. It just Ujjal Bhuya. No, it will not. You have a judgment done. Just Ujjal Bhuya का judgment.
Paragraph.
Ujjal Bhuya का है ना? 2021 Supreme Court cases, Bombay 14100. I'm giving the paragraph. Paragraph 9 onwards. In this case, petitioner was arrested under section 69(1), same 132. The amount is much more.
There are 9.
Para 9, basically the facts. Then Lordship will kindly come to 10, 11, then 39. Reverting back to Arnab Manoranjan Goswami's case, Supreme Court has once again reminded us that the basic rule of our criminal justice system is bail, not jail, in cases of the under trial stage not involving in heinous crimes like rape, murder, terrorism, etc. It is bail and not jail, which is the norm. Insofar as the present case is concerned, notwithstanding the allegation of serious financial impropriety against the petitioner, the case against him is not even at the under trial stage. It is not at the pre-trial stage. That is at the stage where the formal acquisition in the form of first information report or complaint has not been made. Our case is identical. Till now, no formal complaint has been registered. There is no FIR. There is no complaint. The same case is here. The Honorable the Bombay High Court says, at a stage where even formal acquisition in the form of a first information or a complaint has not been made. In such circumstances, we feel that the continuing the detention of the petitioner may not at all be justified in a case of this nature. It is the duty of the Constitutional Court to strike a fine balance between the need of custodial interrogation and the right of the accused to personal liberty. Thus, having regard to the above, we issued the following. Petitioner Anush Kumar shall be released on bail, furnishing a surety of 5 lakhs in remand application so and so. So in my case also, there is no formal acquisition or complaint.
Okay.
Last, our High Court, 2 cases. Then Lordship judgment in identical case. In fact, in most of identical cases, at the stage of anticipatory bail was granted. Subham Jain name was there in the affidavit. That judgment is also there. It was granted on 3rd of April 2025. Same case. So according to him, he is a co-accused. The detailed thing was noted down. The other side counsel is also same. Radhika Agarwal is discussed in paragraph 23. Then paragraph 28. He was also arrested. He was in custody. Accordingly provided 50,000 rupees surety. He was granted bail and he should not interfere with investigation. So this is the judgment of a co-accused of this honorable court. And Lordship judgment 13/3/2025 in Procedural Hawks case, that is under AGST Act, the Assam government part. Here interim bail was given on anticipation and Lordship was pleased to. May I read paragraph 2? The learned counsel for the petition has submitted that all the petitioners are granted interim bail by this court by the order dated 27/1/2025 and in pursuant of the direction of this court that they have appeared before the investigating officer of Dhubri PS and have cooperated with the investigation. They have also submitted all the relevant documents they were directed to produce before the IO. On the other hand, learned PP produced the case diary and submitted the petitioners have appeared before the IO and their statements were also recorded under 180 of BNSS. He has also submitted certain documents before the IO. The learned additional public has submitted that during the course of investigation, it was revealed that the petitioners were using forged documents and they had sufficient materials against them showing their complicity in the alleged offense. He opposed the making of the interim bail as absolute. Now, paragraph 5, though there are materials against the petitioner, suppose Lordship finds any materials against me also. There are materials against the petitioner in the case diary, and since the petitioners have complied with the direction of this court and have cooperated with the investigation, the interim bail granted to them by order dated so and so is hereby made absolute, subject to the condition that they shall continue to cooperate. So I am all along cooperating. All the materials I have submitted, they are not requesting for any further custody. They themselves have said that give him for 15 days judicial custody. On record, I have placed it. So my further detention may not be required. And I assure this honorable court that whatever condition is imposed upon me, I am ready to abide by the conditions. I'm deeply obliged for giving me a patient hearing, highly obliged.
You have any submission?
Any argument has been made that we give reply.
Yes, reply.
May I take leave? My colleagues will be here.
Your Lordship, Radhika Agarwal was cited. And submission was made that no materials is there. Absolutely incorrect. What's the case there is there and the petitioner's application itself says that no formal complaint is being made. Under the GST Act, Lordship, that is provision is there is no requirement of filing any FIR before the police. Power has been given under section 69. Lordship, interestingly, the Radhika Agarwal, section 69 and 71 put under challenge. I want to place that judgment, copy is with your lordship. Paragraph 59 is important, lordship.
Radhika Agarwal, you have given.
If copy is given, my learned friend was referring to some paragraphs of from the.
You have a copy.
Yes, I have a copy. Paragraph 59, page 23.
It could be said.
Paragraph 59.
Yes, absolutely. Radhika. Okay.
Page 23, internal page 23.
Yes,
May I read, Lord?
yes.
Having relying upon the judgment of the, in the case of make my tree supra, it has been submitted on behalf of the petitioner that the power under subsection 2 of section 132 cannot be exercised unless the procedure under section 73 of the act is completed and assessment order is passed, qualifying the tax evaded or erroneously refunded or input tax credit wrongly evaded. According to us, this contention should not be accepted as general or broad proposition. We would accept that normally the assessment proceedings would quantify the amount of tax evaded, etc., and go on to show whether there is any violation of in terms of section A to D of subsection 1 of 132 GST Act. That clause 1 of subsection 1 is attractive, but there could be cases where even without a formal order of assessment, the department revenue is certain that it is a case of offense under clause A to D of subsection 1 of 132 and amount of tax evaded, etc., falls within clause 1 of subsection 1 of section 132 of the Act with sufficient degree of certainty. In such cases, the commissioner may authorize arrest, which when he is able to ascertain the record reasons to believe. As indicated above, the reasons to believe must be explicit and refer to the material and evidence underlying such opinion. There has to be degree of certainty to ascertain that the offense is committed and the offense is non-valuable. The principle of benefit of doubt would equally be applicable and should not be ignored either by the commissioner or by the magistrate when the accused is produced before the magistrate. Now, Lordship authorization or Lordship has seen all the provision of the Act has been followed. There is a tax has been determined and that has been written in the authorization letter also. Then further, Lordship, paragraph 62. Here, Lordship, they have relying on one circular that has also been considered by the Honorable Supreme Court. Paragraph 62, page 25. May I read, Lord?
Yes.
The circular also refer to the procedure of arrest and that the principle of commissioner has to be recorded to on the file. And after considering the nature of the offense, the role of the person involved, the evidence available that is to be reason to believe that the person has committed an offense as mentioned in section 132 of the GST Act. The provision of the code read with section 69(3) of the GST Act relating to arrest and procedure, therefore must be adhered to. Compliance must also be made with the direction of D.K. Basu. The format of arrest as prescribed by the Central Board of Indirect Taxes and Customs in Circular 128 so has also been referred in the instructions. Therefore, the arrest memo should indicate the relevant section of GST Act and other laws. In addition to the ground of arrest must be explained to the arrested person and noted the arrest memo. This instruction regarding ground of arrest came to be amended by the Central Board of Indirect Taxes, Customs, Intelligence, and by the instruction 1 of 25. That is not been placed before Lordship. I brought the notification also. The circular dated 13/1/25 now mandates that the amount of arrest must be explained to the arrested person and also furnished to him in writing as an annexure to the arrest memo. The acknowledgement of the same should be taken from the arrest person at the time of service of the arrest memo. Instruction 2 of 22-23 GST dated so and so further lays down that a person nominated or authorized by the arrested person should be informed immediately, and this fact must be recorded in the arrest memo. The date and time of arrest should also be mentioned in the arrest memo. Lastly, a copy of the arrest memo should be given to the person arrested under proper acknowledgement. The circular also makes the other direction concerning medical examination the duty to take reasonable care of health and safety of the arrested person in the procedure of arresting it, etc. It is laid down the post-arrest formalities which have to be complied with. If further stated that effort should be made to file a prosecution complaint under section 132 of the GST Act at earliest and preferably within 60 days from the arrest, when no bail is granted. When otherwise, the complaint should be filed within definite time frame. The report of arrest made must be maintained and submitted as provided in paragraph 6.1 of the instruction. The aforesaid direction in the circular instruction should be read along with the specific instruction outlined in the earlier judgment of this court and the present judgment. Then Lordship, one notification is referred to. The court has called for the details from the department. Now Lordship may come to paragraph 67. Analyzing the aforesaid data indicates that the number of people arrested is normally in 100 or more. That data reflects that the number of arrests is inversely proportional to the percentage of amount recovered against the amount detected. That is, when the payment are made, the power of arrest is not being exercised. Further, the amount classified as detection amount is not the amount ascertained to assessment adjudication, but amount quantified by the department authority conducting search and seizure. However, it is to be noted that figure which regard to the tax demand and the tax collected would in fact indicate some force in the petitioner's submission that the assessees are compelled to pay tax as condition for not being arrested. Subsection 5 of section 74 of the GST Act gives an option to the assessee and does not confer any right on the tax authority to compel or exact and detaining the arrest. This would be unacceptable and violative of the rule of law. And let's see, regarding breach of the authority has been discussed. Then paragraph 71, there is a provision for compounding of offense also. The petitioners contended that section 162.
No, that is not relevant.
Not relevant. Even then submission was made, the judgment was placed. In that judgment, Lordship, they paid some tax, then bail was granted. Here, Lordship, that is not a similar case. And this case, Lordship, override all the judgment passed by the different high court. So this is a, and exclusively custom and GST was dealt in this judgment. Lordship, now, paragraph 72, page 31.
Yes.
The last issue for determination concern the consideration and validity of section 69 and 70 of the GST Act, which provides for power to arrest and power to summon. The actions assail the virus of these provisions on the ground that are legislative competence. It is submitted that Article 246A of the Constitution, while conferring legislative power on Parliament and the state legislature to levy and collect GST, does not explicitly authorize the violation thereof to meet crime offences. Our attention was drawn to list 1 and 2 of the 7th schedule to the Constitution, which demarcate the legislative field of the Union and the state to enact the law and make violation of the enactment as offensive. Referring to 93 of list 1 of the 7th schedule, it is submitted that the Parliament can enact criminal provisions only for the matter in list 1. It is further submitted that the power to summon, arrest, and prosecute are not ancillary and incidental to the power of levy GST, and therefore are beyond legislative competence of the Parliament under Article 246A of the Constitution, paragraph 73. This argument, in our opinion, must be rejected. Article 246A of the Constitution is a special provision defining the source of power and field of legislation for Parliament and the state and the state legislature with respect to GST. See, my first argument regarding the competence of the learned advocate general appearing, this will fortify my argument. And 246A, special provision with respect to goods and service tax. Notwithstanding anything contained in Article 246 and 254, in Parliament and subject to the clause 2, the legislature of the every state have power to make laws with respect to goods and service tax imposed by the union or by the state. 2. Parliament has exclusive power to make laws with respect to goods and service tax, where the supply of goods or service or both takes place in the course of interstate trade or commerce. Explanation. The provision of the article shall in respect of the goods and service tax referred to in clause 5 of Article 279. 279A takes effect from the recommendation of the Goods and Service Tax Council. All lordship finance minister of the state are the member of the council. They take decision it populated all the states, including the central. Tax, as I submitted earlier, tax is divided 50-50 between the state and the central. The paragraph 74. The court in Union of India versus so took the change brought by Article 246 of the Constitution as observed. 52A. Finally, the Article 246A defines the source of power well as defined in the field of legislature with respect to goods and service tax, awaiting the need to travel to the 7th schedule. 52.2. Secondly, the provision of Article 246A are available both to Parliament and the state legislature, save and except for the exclusive power of Parliament to enact GST legislation, where the goods of supply or service tax place in course of interstate trade or commerce. Paragraph 75. The Parliament under Article 246 of the Constitution has power to make laws regarding GST and a necessary corollary enact provisions against tax evasion. Article 246A of the Constitution is comprehensive provision and doctrine of faith and substance applies. The impugned provisions laid down the power of summons and arrest, power of necessary for the effective levy of collection of GST. Time and again, this court held that while deciding the issue of legislative competence, entries should not be read as a narrow or pedantic sense, but give their broadest meaning and the widest amplitude because they are instinct to a machinery of the government. Then notes of judgments are referred. Then the ambit of an entry or article laying down the legislative field extend to all ancillary and subsidiary matters which fairly and reasonably it can be said to be comprehended in it. The notes of judgment has been placed. Subparagraph 47. The principle in constituting the word conferring legislative power is the most liberal construction should be put on the words so that they may have to affect their widest amplitude. None of the items in the list is to be read in narrow restricted.
So in this case, the Supreme Court has said that the union government can legislate on GST matters and it can also prescribe punishment
Yes.
for violation of.
The state has also given power under 246 to.
So state has also legislated a state GST Act,
Yes.
but both acts are separate.
Section 6. That's why I placed section 6. And Supreme Court in Armour's case has defined the role of the state and central laws. There is a concurrent jurisdiction to the state and if they had submitted when we are going to purchase some goods, then we are taking bills. In the footnote, it is stated how much tax has been collected on behalf of the state and the center. If it is 18%, then 9% on behalf of the state.
No. The question before the court regarding appearance of Advocate General
Yes,
is very simple. That this is a criminal proceeding, is penal consequences are there. And prosecuting agency is union government under CGST Act in the present case. Your submission is that there is a conflict of interest because
For section six,
state would have got some share of the
yes,
tax.
section 269 and 266 speaks about consolidated fund loans. And 269 strictly dealt with the provision of the GST Act.
Okay.
And all the circulars or the notifications issued by the central government are adopted by the state government. And at least one notification of the state government also looks. It is very clear with by the finance department. Then let's see. Same, I'm reading further. Thus, the penalty and prosecution mechanism for the levy of collection of GST and for checking its revision, it is permissible, exercisable legislative powers. The GST Act in pitch and substance pertains to Article 246A of the Constitution, and the power to summon and arrest procedures are ancillary and incidental to the power to levy and collect the goods service tax. In view of the court said, the virus challenge under section 69 and 70 of the Act must fail and accordingly rejected. In some of the cases, now Lordship may come to paragraph 12. The supplement judgment by the learned Judge of the Supreme Court, paragraph 12. Last page.
Yes,
Married law.
yes.
It is pertinent to note that the special act are enacted to achieve the specific purpose and objective. The power of judicial review in cases of arrest under special act could be exercised very cautiously and in rare circumstances to balance the individual liberty and the interest of justice and of the society at large. Any liberal approach in constituting the stringent provision of the special act may frustrate the very purpose and objective of the act.
But your submission is GST Act is not an exhaustive act as regards the penal consequences are there.
No, Lordship,
So the provisions of BNS would be applicable.
Lordship, in effective way and Lordship may please to go through the case diary. All provision has been followed, Lordship. Regarding section 47, 48, everything has been followed.
And 35 also.
35, Lordship, that is in view of the judgment, Lordship. We have followed that also in press memo, that reason to believe, Lordship, everything is there.
Okay, I will.
Then Lordship, interestingly, this has been further. It is hardly need to be stated that the offense under PML Act or the Custom Act or FERA are the offense of very serious nature, affecting the financial system and in turn of sovereignty of the integrity of the nation. The provisions contained in the said act, therefore, must be construed in the manner which would enhance the objective of the act and not frustrate the same. Frequent or casual interference of the court in functioning of the authorities, officers who have been specially conferred with the power to combat the serious crimes may embody the unscrupulous element to commit such crime and may not be to do justice to the victims, who in such cases would be the society at large and nation itself. With the advancement of the technology, the very nature of crime has become more and more distinct and complicated. Hence, minor procedural lapse on the part of the authorities may not be seen with magnifying glass or by courts in exercise of power of judicial review, which may ultimately end up granting undue advantage or benefit to the persons accused of very serious offences under the special act. Such offences are against the society and against the nation at large and cannot be compared with the ordinary offences committed against an individual, nor the accused in such cases compared with the accused of ordinary crimes. And Lordship in case diary and Lordship on submission was made regarding Shubham Jain. He is not the co-accused. Check bill was issued to him, and against him, Lordship, we have already launched the prosecution that is pending. And this is entirely different case. And Lordship, on that day, when the urgent accused was arrested, one accused was granted bail on flimsy ground. We had challenged that before the learned session judge for cancelling of the bail. That is fixed on 11th/9. Similarly, one accused was granted bail in Tinsukia when we filed transit remand. Then he was granted bail. That is, we also filed revision before this honorable court. And in one case, Lordship, that we have filed for cancellation of bail, he has already fled from the jurisdiction of the court, Lordship, authorities. His wife submitted an application before the authority that my husband is ready to cooperate. And when we asked him to appear, he filed an application that my husband is taking the treatment in Rajasthan, Churu. This is the address of the accused person in all the cases. That's why, Lordship, the commissioner has come to this finding that he may flee from the jurisdiction of the court because apparently, Lordship, they have committed fraud on the nation.
Okay.
And Lordship, in case of Jagan Reddy, paragraph 15 and 16. Paragraph 15 Lordship. Economic offense constitute a class apart, need to be visited with different approach in the matter of bail. An economic offense, a deep-rooted conspiracy and involving huge loss to the public fund need to be viewed seriously and considered as grave offenses affecting the economy of the country as a whole and thereby posing serious threat to the financial health of the country. While granting bail, the court has to keep in mind the nature of accusation, the nature of evidence in support thereof, and severity of the punishment with conviction will entail the character of the accused, circumstances which are peculiar to the accused, reasonable possibility of securing presence of the accused at trial, reasonable apprehension of the witnesses being tempered with the larger interest of the public state and other similar considerations. Lordship, I'm making one submission. Lordship, we have launched prosecution in as much as not less than 10 cases. In none of the cases, Lordship, accused is appeared. Even warrant has been issued in many cases. This is the reason for Lordship and keeping the accused in the jail. And Lordship, we have filed an application where we approach the learned jail.
In this case, you have not yet filed complaint. You
No,
are collecting evidence.
Yes, Lordship.
Then you will be filing complaint.
Yes,
Suppose that the evidence is deficient, what would be the course?
then we have to, if he is in jail for 60 days, we have to file complaint within 60 days because 167 will come into play. Then he is entitled to default bill. Then the notification says that if the accused is in jail, then invariably we have to file the complaint within 60 days. If he's, if in any cases we cannot file, then let's say within a shortest period we have to file. And let's say in this case, we have given the order of law, CGM at 30th of August, and court has allowed us to interrogate the person in jail on 2nd of September.
Okay.
In case that Lordship, everything is there, we have placed before your Lordship, Lordship can go through and we have trademarked.
You'll require case diary tomorrow.
Lordship can use the same. Or Lordship, we can wait for there.
How will you record the statement without
Because we are keeping the photocopy. in our-
supplementary
Yes.
case diary?
Because maintaining the register.
Okay. Heard. Mr. D. Soikia, learned senior counsel assisted by Ms. N. Havelia, learned counsel for the petitioner. Also heard Mr. S.C. Kyal, learned standing counsel,
PCCI.
DGGI. Let this case be listed for delivery of orders day after tomorrow. 3rd of September. You give me the case diary.
Yes, Lordship, case there. Lordship, before Lordship, my submission will be that regarding that competency of the advocate general preparing the cases of GST.
That I will address.
That is to be said, because it will go a long way. Lordship.
Lordship, only
3rd of September.
even though I don't want to submit anything, only thing is that
he said that Subban Jain is not a co-accused. Lordship, in their own affidavit, paragraph 3.3.3, he has named them. That is the only submission I want.
We have
Nothing.
made
I
the
can't-
name, because he's not the co-accused. Egg bill was issued in his name, that we have clarified Lordship in our opinion.
Much obliged.
Okay, the case 9. On based upon offense report, the 3 persons were there. One is responding and 2 accused person is there, and accused number 1, your lordship. Case 10. Nikumani Rajbangshi, your lordship, and the section extracted your
Who is appearing for? State is appearing.
wildlife.
Special PP.
Special PP would be required. We'll take it up at 2.
Okay, sir.
You inform the special PP.
Okay.
Item 4. May I please, your lord. Lordship, here in this case, Lordship, the petitioner was arrested on 14/6/2025. And as on today, Lordship, 79 days. Lordship, here will find page 11, Lordship. Lordship, in FIR,
Oh, POXO is there.
in the FIR, Lordship, the informant stated that the victim's age was 15 years, Lordship, but I have annexed the school certificate of the victim.
We'll issue notice.
Lordship.
Heard Mr. I.U. Chaudhary, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. Call for the case diary and stop, issue notice to respondent number 2. The petitioner shall take steps for issuance of notice upon respondent number 2 in person to the prevailing notification of the registry in this regard within 3 days from the date of this order, returnable on 18 September. List accordingly.
Keep you.
Item 5.
May I please, your lordship, quantitative BNSS application, lordship. The statutory matter, lordship. The allegation is under section 8 of the POXO Act, lordship.
POXO,
POXO, section 8 of.
what is the stage of the trial?
The statute has been submitted, lordship. The witness is yet to be examined, lordship. The 49 days in custody, lordship.
Let the victim be examined, then you come.
No, lordship, the FIR, your
What
lordship,
are your grounds? You are on merit.
I haven't made, lordship.
Heard Mr. T. Sutia, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. Call for the scanned copy of the trial court records as well as scanned copy of the connected case diary from the trial court. Registry to take steps for requisitioning the scanned copy. Also issue notice to the respondent number 2. Stop. The petitioner shall take steps for issuance of notice upon respondent number 2 in pursuant to the notification of the registry, prevailing notification of the registry in this regard within 3 days from the date of this order, returnable on 18 September. 18 September. No. List accordingly.
Obliged, lordship.
MURDER,
MER, my lord, MERT,
merger,
merger,
okay.
between my lord respondent number 1 and 2. So my lord, after receiving the complaint, my lord petition, my lord petitioner came to know my lord that my lord the murder was my lord done between my lord. So my lord, and
Who is appearing for the state?
state my lord, after issuing notice, my lord, they may.
But question of maintainability is there.
Yes, my lord. Maintainable, my lord, entire transaction, cause of action arose here, my lord, Guwahati, my lord.
No, no,
And check was also issued, my lord, to the respondent number
no,
1.
that is not my query. My query is, you are aggrieved with an order of taking cognizance passed by a Kolkata court. Which is the appropriate court to quash that order? Whether this court can quash or what? You have to show me the authority.
My lord, my petitioner approached my lord regarding my lord jurisdictional issue, my lord. Right, well,
No, you are challenging the order of a court of judicial magistrate situated at Kolkata, who is under the jurisdiction of Kolkata High Court.
But my lord, they can, my lord, the file, my lord, enact, my lord, Calcutta, but my lord, they have not, my lord, check was issued, my lord. Even my lord, I have no intimation, my lord, by the respondent 1 as well as my respondent number 2 also, my lord.
No, no, that is not my query.